Excuse me, sir. I need to see some identification. Now.
I'm working. Is there a problem, officer?
This is a secure facility. You need to prove you're authorized.
I come here regularly. I have full access to this library.
Huh. Okay, sure. IDs can be faked. Come with me now.
Officer, I've shown you my credentials. What's the actual issue?
Don't lawyer.
Excuse me, sir. I need to see some identification, now. The Crawford County Law Library. Tuesday afternoon, 2:47 p.m. Fluorescent lights hummed above mahogany tables where attorneys researched cases in hushed concentration. The smell of aged leather-bound legal volumes mixed with fresh coffee from the break room. Pages turned softly. Keyboards clicked. Marcus Whitmore looked up from his stack of case reporters, yellow legal pad covered in meticulous notes. A uniformed officer stood over him, hand resting on his duty belt near his weapon. "I'm working. Is there a problem, officer?" "This is a secure facility. You need to prove you have authorization to be here." Whitmore's expression didn't change. He'd been through this before. Different location, different officer, same script. "I come here regularly. I have full access." "That's not what I asked. Identification now." What happened in the next 8 minutes would end a career, expose a pattern 9 years in the making, and force Crawford County to confront an uncomfortable truth about who gets presumed criminal and who gets presumed credible. To understand why this moment represented such a catastrophic failure of judgment, you need to know exactly who was sitting at that table. The man reviewing those case files wasn't just any attorney. Marcus James Whitmore, 41 years old, district attorney for Crawford County, Georgia. He'd graduated magna cum laude from Howard University in 2005 with a degree in political science. 3 years later, he earned his J.D. from Yale Law School, where he'd served as an editor for the Yale Law Journal, a position reserved for the top students in each class. Whitmore started his legal career as a public defender, representing indigent clients from 2008 to 2012. His record during those 4 years, 156 cases, 89% favorable outcomes. He understood the system from both sides. In 2012, he switched to prosecution. As an assistant district attorney, he handled 340 felony cases over 6 years, achieving a 94% conviction rate on violent crimes. He created a juvenile diversion program that reduced recidivism by 37% and secured $2.3 million in federal grants for victim services. In 2018, Crawford County elected him district attorney. He won with 58% of the vote. 4 years later, they re-elected him with 64%. As DA, Whitmore oversaw an office of 47 attorneys managing a $8.6 million annual budget. Every criminal prosecution in a county of 430,000 residents crossed his desk. The state's attorney general once said, "Marcus Whitmore represents the highest standard of prosecutorial integrity. His office is a model for balanced justice, tough on crime, fair on process." Whitmore was married 14 years to a pediatric surgeon, 2 children. He coached the youth mock trial team, served as deacon at First Baptist Church. Defense attorneys respected him. Victims' families trusted him. Police worked with him. On February 20, 2024, he was at the law library researching precedents for an upcoming appeals case. He'd been there since 1 o'clock. He was wearing business casual, no suit, no tie. Navy sweater over a dress shirt, khakis, reading glasses. It was research day, a routine Tuesday afternoon. But the officer who approached him that day had been in law enforcement for exactly 11 months, and he was about to make a judgment that would define his entire career. Officer Tyler Brennan, 26 years old, badge number 847. He'd graduated from the Crawford County Sheriff's Academy in March 2023. The incident at the library occurred 11 months later, February 2024. Brennan grew up in rural Whitfield County, a community that was 92% white. He earned a criminal justice degree from a regional state university, no military service. He'd applied to 3 departments before Crawford County accepted him. At the academy, he graduated 18th out of 31 cadets. His training records showed he'd struggled with de-escalation and implicit bias modules. His evaluation noted he needs improvement in cultural competency. In 11 months on the job, Brennan had logged 127 documented interactions, 34 arrests, mostly traffic warrants and misdemeanors, 0 commendations. But there was something else in his file. 3 complaints, all within his first 11 months. Month 3, a black woman complained about aggressive questioning during a routine traffic stop. The complaint was investigated by Sergeant Morrison, Brennan's supervisor, finding unfounded. Month 7, a Hispanic man complained about excessive force during a warrant arrest, investigated by Sergeant Morrison, finding within policy. Month 9, a black teenager complained about racial profiling at a shopping mall, investigated by Sergeant Morrison, finding unsubstantiated. 3 complaints, 3 different people, 1 thing in common, they were all non-white, and 1 other thing in common, they were all dismissed by the same supervisor. Brennan consider. D himself thorough, by the book. He told fellow deputies he wasn't going to be too politically correct doing his job. 1 month before the library incident, Sergeant Morrison retired. A new supervisor, Lieutenant Elena Ramirez, took over. She implemented more rigorous complaint reviews. Brennan hadn't adjusted to the new oversight. On February 20th, 2024, he wouldn't have the protection of his old supervisor. He was about to discover that evidence doesn't lie, and body cameras don't dismiss complaints as unfounded. Tuesday, February 20th, 2024, 2:47 p.m. Outside, the temperature sat at 38 degrees under overcast skies. Inside the historic law library, a marble-floored, wood-paneled building adjacent to the county courthouse, attorneys wore layers against the chill. Marcus Whitmore had cleared his afternoon calendar for uninterrupted research time, standard practice when preparing appellate briefs. He'd been at his corner table since his 1 o'clock lunch break, surrounded by 3 stacks of case reporters. His yellow legal pad was filled with citations and arguments. His laptop displayed a half-written motion. The county law library served as shared research space for prosecutors, public defenders, and private attorneys. Whitmore had an office in the DA building across the street, but the library housed specialized appellate resources. He'd signed the electronic access log when he arrived, his name recorded, time stamped, permanent access badge scanned. At 2:35 p.m., 12 minutes before Officer Brennan arrived, courthouse security received an anonymous call. The dispatch log recorded it word for word. Suspicious black male in law library. Doesn't look like he belongs. Possibly homeless person using library for shelter. The description: male wearing casual clothes, sitting alone, multiple bags. The bags were Whitmore's litigation files. Officer Brennan took the call without requesting additional information. He didn't check the library's electronic sign-in log. He didn't radio for identification assistance. He didn't ask the librarian if anyone matched that description. He made 3 assumptions in the 90 seconds it took to walk from the courthouse to the library. Each one was wrong, and he never questioned a single one. At 2:47 p.m., Officer Tyler Brennan pushed through the library's heavy oak doors. He scanned the reading room. His eyes settled on Marcus Whitmore at the corner table. The body camera on Brennan's chest captured every word of what happened next. Whitmore first became aware when a shadow fell across his legal pad. He looked up. Officer Brennan stood over him, feet spread in a power stance, hand resting on his belt near his service weapon. "Excuse me, sir. I need to see some identification, now." Whitmore's first thought, not again, deep breath, stay calm. "Good afternoon, officer, I'm working. Is there a problem?" Brennan's tone was authoritative, final. "This is a secure facility. I need to verify you have authorization to be here. ID, please." Whitmore glanced around the reading room. 3 other attorneys sat at tables, all white, all similarly dressed in business casual, all surrounded by legal materials. None had been approached. "I come here regularly. I have full access. What specific concern do you have? Sir, I'm not going to ask again. Identification. Whitmore slowly reached for his wallet. He removed 2 items, his state bar card and his county building access badge. The bar card showed his photo clearly. State Bar of Georgia, attorney license 207,845, Marcus J. Whitmore. The access badge bore the county seal, unrestricted access, Crawford County Government. He placed both on the table in front of Brennan. Here's my bar card and building access badge. As you can see, I'm an attorney with full authorization to be here. Brennan barely glanced at them. He picked them up, looked for perhaps 3 seconds, then handed them back dismissively. These could be faked. How do I know you didn't just find these, print them at home? Whitmore's eyebrows raised slightly. You think I fabricated state bar credentials? Brennan became defensive. I'm just doing my job. We had a call about a suspicious person. You match the description. What description would that be, officer? Brennan realized his error. He deflected. Look, just cooperate and we can clear this up quickly. Come with me to verify your identity. Whitmore placed both hands flat on the table. His body language deliberately non-threatening. His voice remained measured. Officer, I've shown you valid credentials. I'm engaged in lawful activity in a public building where I have documented access authorization. What reasonable suspicion of criminal activity do you have? The legal language seemed to catch Brennan off guard. His tone became more aggressive. Don't lawyer talk me. I need you to come with me right now to verify your identity at the security desk. Whitmore didn't move. I'm not going anywhere. I have a constitutional right to be here. You have no legal basis to detain me. Brennan's hand moved to his handcuffs. Are you refusing to comply with a lawful order from a law enforcement officer? Whitmore's voice dropped, deadly calm. I'm asserting my Fourth Amendment rights against unlawful seizure. You're welcome to verify my identity, but you'll do it here, or you can call your supervisor. Brennan, feeling his authority challenged. I don't need my supervisor to tell me when someone's being uncooperative. Last chance. Whitmore felt a flash of controlled anger. He'd prosecuted Fourth Amendment violations. He trained officers on reasonable suspicion. And now he was being detained without cause in a building where his name was literally on the directory. You're really going to do this? Whitmore had had enough. He reached for his laptop bag and extracted his business card holder. He removed one card and placed it deliberately on the table between them, facing Brennan. The embossed lettering was clear. MARCUSJWHITMORE District Attorney, Crawford County. The county seal, office phone number, official email address. My name is Marcus Whitmore. I'm the district attorney for this county. This is our law library. I'm researching a case, and you've just detained your boss without cause. Silence. Absolute silence. Officer Brennan's face went from tan to pale to red in 3 seconds. His mouth opened, closed, opened again. You didn't, I wasn't told. Whitmore continued, each word precise and measured. What criminal activity did you observe? Brennan stammered. No coherent response emerged. I'll need your name and badge number, and you're going to call Lieutenant Ramirez, right now. What followed was 8 minutes of methodical questioning that would be studied in police academies for years to come. Whitmore's voice remained calm, professional, but each question landed with prosecutorial precision. Officer Brennan, what reasonable suspicion did you have to stop me? Brennan fumbled. The dispatch call said suspicious person. Did you verify what made me suspicious before approaching me? I observed you sitting here. Observed me doing what exactly? Reading law books in a law library. Silence. Did you check the library sign-in log before demanding my identification? No, sir. Did you ask the librarian if I had authorization to be here? No, sir. Did you request dispatch to provide any additional information about the nature of the call? No, sir. What specifically about my behavior sitting at a table, reading legal materials, taking notes, suggested I was engaged in criminal activity. Brennan's defense was crumbling. I mean, the call said you didn't look like you. Didn't look like what, Officer Brennan? The question hung in the air, unanswerable without admitting the bias that drove the entire interaction. Whitmore shifted into prosecutor mode. You detained a citizen without reasonable suspicion. That's a Fourth Amendment violation. You demanded identification without legal justification. You rejected valid credentials without verification. You threatened arrest for the assertion of constitutional rights. You profiled based on appearance rather than conduct. At that moment, the library doors opened. Two deputies entered, called by the librarian who'd watched the entire encounter with growing alarm. Deputy Mitchell, a 15-year veteran, immediately recognized Whitmore. His expression shifted to horror. District Attorney Whitmore, is there a problem here? The tone of his voice made clear he already knew the answer. Deputy Mitchell, yes. Officer Brennan detained me without cause while I was conducting legal research. His body camera has recorded everything. Brennan desperately, sir, I was just responding to a call. I didn't know who you were. Whitmore cut him off. The problem isn't that you didn't know who I was. The problem is that you made assumptions about whether I belonged here based on how I look. If I were a white attorney at this table, would you have approached me the same way? Brennan couldn't answer. Whitmore turned to Deputy Mitchell. I want a copy of the body camera footage. I want the dispatch recording of the initial call, and I want Lieutenant Ramirez here within 15 minutes. This isn't personal. This is procedural. This encounter represents a civil rights violation, and it will be investigated thoroughly. The body camera had captured everything, and what it showed would become Exhibit A in an investigation that would expose much more than one bad stop. Officer Brennan walked out of the library at 3:04 p.m. 17 minutes. That's how long it took to end a law enforcement career. He returned to the courthouse security station visibly shaken. Security camera footage later showed him telling a fellow deputy, I think I messed up really bad. He didn't yet know how bad. Lieutenant Aunt Ramirez arrived at the library at 3:11 p.m. Whitmore's call had reached him within 2 minutes. Ramirez immediately apologized and requested a statement. Whitmore's response was measured but firm. This isn't about an apology to me, Lieutenant. This is about a pattern. I'm the DA. I'll be fine. But how many people has Officer Brennan treated this way who couldn't identify themselves out of an unlawful detention? Ramirez's face showed he understood the implication. By 3:30 p.m., Brennan was summoned to the sheriff's administrative offices. He was placed on immediate administrative leave. Badge and service weapon surrendered. Whitmore returned to his office across the street and formally filed a complaint with Internal Affairs. Despite his position, he wanted it investigated like any civilian complaint would be. He contacted the county attorney about the civil rights implications. By 4:15 p.m., a local courthouse reporter who'd heard the radio traffic began making inquiries. At 5:30 p.m., the sheriff's office issued a statement. We are aware of an incident involving one of our deputies and are conducting a thorough investigation. The deputy has been placed on administrative leave pending the outcome of that review. That evening, Sheriff Raymond Miller personally reviewed the body camera footage. According to staff present, his only comment was, "This is indefensible." The investigation was assigned to Lieutenant Ramirez and the Internal Affairs Division. Within hours, they'd secured the dispatch recording, traced the anonymous call, and pulled Brennan's complete personnel file. That night, Whitmore discussed the incident with his wife, a surgeon who'd experienced similar profiling in a hospital parking garage. They talked about their children, about having the talk, about whether credentials and education ever really protect you. Whitmore made a decision. This was bigger than personal vindication. Internal Affairs assigned 2 senior investigators the next morning. They had a specific mandate determine not just what happened in the library, but whether this was an isolated incident or a pattern. What they uncovered in the next 8 days was worse than anyone anticipated. Lieutenant Elena Ramirez led the investigation alongside Internal Affairs, Sergeant David Park, and Civilian Oversight Representative Patricia Freeman. 8 intensive days, February 21st through 28th. They reviewed 127 hours of body camera footage, every interaction Brennan had recorded in 11 months, 89 dispatch records, his complete personnel file, academy evaluations, field training reports, monthly performance reviews. They reopened all 3 previous complaints that Sergeant Morrison had dismissed. The library's electronic sign-in log showed Marcus Whitmore had visited 47 times in the past year. His access was documented, routine, unquestionable. Investigators interviewed 14 witnesses, the librarian, other deputies, courthouse staff, and critically, the 3 people who'd previously complained about Brennan. Whitmore provided an 8-page written statement. He declined to influence the investigation in any way. He recused himself from any prosecutorial involvement. Brennan was interviewed twice. His defense: I was following my training. I had reasonable suspicion based on the dispatch call. I would have done the same thing to anyone. But the investigators found something else. They analyzed every one of Brennan's 127 documented interactions over 11 months. 73 involved white citizens, 57% of his total contacts. 54 involved non-white citizens, 43%. Crawford County's demographics: 71% white, 29% non-white. Brennan was disproportionately contacting non-white citizens, but it got worse. Of his interactions with non-white citizens, 67% resulted in a demand for identification. Of his interactions with white citizens, only 23% resulted in an ID demand. 3 use-of-force incidents in 11 months. All 3 involved non-white individuals. The investigators re-examined the 3 previous complaints with fresh eyes and contacted the complainants directly. Complaint number 1, May 2023. Shauna Williams, 34, black woman, attorney at a private firm, stopped for a broken taillight that wasn't broken, asked for ID 3 times. Brennan searched her car without clear consent. Body camera showed him saying, "You don't mind, right?" while already opening the door. She'd responded, "I actually do mind," but he continued the search anyway. 15 minutes on the side of the road, released with a warning. Sergeant Morrison's finding: traffic stop within policy, verbal consent obtained for search. The investigation revealed Morrison never interviewed Williams, never reviewed the body camera footage showing her explicit objection. Complaint number 2, September 2023. Carlos Mendez, 27, Hispanic man, outstanding warrant for unpaid parking tickets. Brennan located him at his workplace and arrested him in front of colleagues using what witnesses described as excessive force, arm wrenched behind his back, forced to the ground despite full compliance. Body camera footage showed Mendez saying clearly, I'm not resisting," while Brennan applied force. Sergeant Morrison's finding: force appropriate for warrant apprehension, subject tensed muscles indicating potential resistance. The body camera contradicted Morrison's report: no visible tensing, no resistance. Complaint number 3, December 2023. Jamal Harris, 17, black teenager, stopped at the mall for matching description of a shoplifting suspect. The description from dispatch: black male, approximately 5'10", wearing gray hoodie. Jamal Harris was 62 and wearing a blue jacket. Brennan detained him for 25 minutes until mall security confirmed the actual suspect had been caught on a different floor. Sergeant Morrison's finding: reasonable detention based on dispatch information, released when description was clarified. Morrison's report didn't note the obvious physical discrepancies, didn't question why Brennan never verified the description before detention. The pattern was undeniable: 3 complaints, 3 non-white complainants, 3 incidents showing the same assumptions, the same disregard for explanations, the same bias in enforcement. And 3 investigations by Sergeant Morrison that rubber-stamped Brennan's conduct without scrutiny. Investigators discovered Morrison had supervised Brennan's entire 11-month tenure. In that period, Morrison had dismissed 12 complaints against various deputies. 11 involved non-white complainants. Dr. Jennifer Walsh, a police practices expert from the State University, reviewed the body camera footage at the investigators' request. Her conclusion: Officer Brennan exhibits classic indicators of implicit bias, selective enforcement, heightened suspicion toward people of color, and confirmation bias that interprets neutral behavior as threatening when the subject is non-white. The investigation report, submitted February 28, was 73 pages with 14 exhibits. Specific violations in the Whitmore incident: Fourth Amendment, unlawful detention without reasonable suspicion; Department Policy 4.12, failure to verify information before citizen contact; Department Policy 6.03, demanding identification without legal justification; Department Policy 8.21, failure to de-escalate when no threat was present; Training Standards, failure to apply implicit bias recognition training. Pattern finding: Officer Brennan demonstrated a consistent pattern of disparate treatment based on race, failed to apply constitutional standards in his enforcement decisions, and exhibited implicit bias. County Attorney David Brenner issued a legal opinion. The Whitmore incident, combined with the pattern of similar complaints, represents significant civil rights liability for the county. Each of these stops raises Fourth and 14th Amendment concerns. The investigation's conclusion: Officer Brennan's pattern of behavior, combined with Sergeant Morrison's systematic failure to properly investigate complaints, indicates both individual officer bias and institutional oversight failure. The Whitmore incident was not an anomaly. It was the inevitable result of 11 months of unchecked problematic policing. Recommendation: immediate termination. Secondary recommendation: review all of Brennan's arrests for potential constitutional violations. Referral to the State Attorney General's Civil Rights Division. The investigation's findings were unequivocal. The recommendation was termination, but the consequences would extend far beyond one officer's career. The Sheriff's Deputies Union initially filed a grievance on Brennan's behalf. The union argued he deserved progressive discipline, suspension, retraining, probation. Sheriff Raymond Miller held firm. This isn't a training deficiency. This is a pattern of constitutional violations and egregious judgment. On March 5, after the union's attorneys reviewed the complete investigation, including the body camera evidence, the previous dismissed complaints, and Morrison's failures, the union withdrew its grievance. Their statement: upon review of the complete evidence, we cannot defend this conduct. March 7, 2024. 11 months and 14 days after graduating from the academy, Officer Tyler Brennan was terminated from the Crawford County Sheriff's Department. He filed no appeal. The Crawford County District Attorney's Office, with Whitmore recused, declined to file criminal charges but referred the case to the State Attorney General's Civil Rights Division for review. In June 2024, Shauna Williams, the attorney from complaint number 1, filed a federal civil rights lawsuit against Brennan and the county. The case settled in October for $175,000. The county paid the settlement. Brennan was individually liable for $25,000. Carlos Mendez is considering a similar lawsuit. Jamal Harris's family received a formal apology from the county and a commitment to policy reforms. In May 2024, the Georgia Peace Officer Standards and Training Council held a hearing on Brennan's law enforcement certification. They voted to revoke it. He cannot work as a police officer anywhere in Georgia. Brennan attempted to transfer his certification to South Carolina. The request was denied. Georgia's revocation appears in the National Law Enforcement Database. Tyler Brennan now works as an armed security guard at a private industrial facility in rural Georgia, a position that doesn't require law enforcement certification. He lives with his parents. His wife filed for divorce 2 months after his termination. He has issued no public apology. His only statement, given to a local reporter in March 2024, "I made mistakes. I'm not a racist. I was trying to do my job." But Brennan's termination was just the beginning of the consequences. The financial cost to Crawford County: Williams' settlement $175,000, legal defense costs $89,000, investigation costs $23,000, policy reform implementation $156,000, potential liability reserves $50,000, total $493,000. Leadership accountability: Sergeant Morrison had retired in January 2024, 1 month before the Whitmore incident, but the investigation revealed his systematic dismissal of complaints. The county attorney is reviewing his pension under Georgia's dereliction of duty clause. That review is pending as of November 2024. Morrison's name was removed from the department's Wall of Honor. The annual Morrison Award for exemplary supervision was renamed. Sheriff Miller publicly apologized. He committed to comprehensive reforms. His 2024 re-election campaign included a criminal justice reform platform addressing bias and accountability. Community trust surveys told the story. In March 2024, only 34% of Black residents reported trusting the sheriff's department. That number was down from 61% the previous year. Deputy Mitchell, who'd responded to the library and handled the situation professionally, received a commendation. 2 other deputies who'd worked closely with Brennan were retrained on bias recognition and placed under enhanced supervision for 6 months. The department implemented 8 major reforms. Number 1, complaint investigation overhaul. All complaints now go directly to internal affairs, not supervisors. A 7-member civilian oversight board reviews all findings. Body camera footage is mandatory for every complaint review. Complainants are interviewed within 48 hours. Quarterly public reports on complaint statistics and patterns. Number 2, early warning system. An automated database tracks complaints, use of force, citizen contacts by demographics, and vehicle stops. The system flags patterns, triggers. 2 complaints of similar nature require mandatory retraining. 3 complaints trigger fitness for duty evaluation. The system identified 4 other deputies with concerning patterns. All were retrained, 1 resigned. Number 3, bias recognition training. 40 hours of mandatory training for all deputies, completed by August 2024. Scenario-based training using the Whitmore incident as a case study, with Whitmore's permission. Quarterly refresher sessions. Academy training extended from 18 to 22 weeks with an additional 32 hours on constitutional policing. Number 4, body camera policies. Cameras now mandatory for all citizen interactions. Footage automatically uploads to secure cloud storage with no local deletion possible. Supervisors must review 10% of each deputy's footage monthly. Public portal established for footage requests. Footage retained for 3 years, up from 90 days. Number 5, verification technology. Mobile data terminals upgraded with photo ID verification systems. Deputies required to check electronic sign-in logs before approaching individuals in secured county facilities. Dispatch protocols changed to require more detailed information. Anonymous tip policy revised. Specific articulable facts required, not vague suspicions. Number 6, supervisor accountability. Supervisors held accountable for deputies under their command. Complaint patterns reflect in supervisor evaluations. Promotion eligibility requires a clean complaint record for 2 years. Number 7, community oversight. The County Commission passed the Crawford County Law Enforcement Accountability Act, codifying civilian oversight, early warning systems, and mandatory reporting requirements. Number 8, the Whitmore Protocol. Any detention in a county facility now requires verification with facility staff before demanding identification. The reforms didn't stop at Crawford County. The Georgia Attorney General's office reviewed 47 other complaints across the state that had been dismissed by supervisors without proper investigation. 12 cases were reopened. 3 additional officers were termina. Ted Morrison's supervision practices were identified as a systematic failure, leading to a state mandate that supervisors can no longer investigate complaints against their own subordinates. The Whitmore incident video, with identifying information redacted, is now used in Georgia Law Enforcement Academy curriculum. Every new police recruit in the state sees it. The county established a $50,000 fund for individuals who'd filed complaints against Brennan that were improperly dismissed. Williams, Mendez, and the Harris family all received compensation and formal apologies. The local NAACP chapter partnered with the Sheriff's Office on community policing initiatives, including a ride-along program and youth law enforcement mentorship. The case was studied in police accountability research. It was cited in the U.S. Commission on Civil Rights 2024 report on law enforcement bias. 4 other Georgia counties adopted similar early warning systems and civilian oversight models based on Crawford County's reforms. November 2024, Marcus Whitmore was re-elected district attorney with 68% of the vote, an increase from 64% in 2022. He created the Constitutional Policing Initiative in his office. Every arrest is now reviewed for constitutional violations before charging decisions are made. He speaks at National District Attorneys Association conferences on implicit bias and accountability. He co-authored a law review article, When Prosecutors Become Victims, Police Accountability from the Inside. He testified before the state legislature on police accountability reform bills. He maintains relationships with Shauna Williams, Carlos Mendez, and Jamal Harris. All 3 have spoken at community forums about their experiences. 18 months after the reforms were implemented, early data shows results: 41% reduction in complaints, 67% reduction in dismissed complaints. Community trust surveys show improvement, 34% to 52% among Black residents. Still work to do, but measurable progress. The case is mandatory viewing at Georgia Law Enforcement Academy. 35,000 officers have been trained using it since 2024. Law schools use it in constitutional law courses. Civil rights organizations cite it in training and litigation. What the case revealed: even highly credentialed professionals aren't immune to racial profiling. Credentials shouldn't be necessary to avoid unlawful detention. Constitutional rights apply equally, regardless of position or authority. The universal lesson: evidence matters. The body camera saved this case. Without video, it would have been Brennan's word against Whitmore's. Even as district attorney, Whitmore might not have prevailed without documentation. The Fourth Amendment protects everyone from unlawful seizure. Police must have reasonable suspicion of criminal activity. Mere presence in a location, even when someone thinks you don't belong, is not suspicious. Accountability requires multiple elements working together: evidence through body cameras, oversight through civilian review, consequences when violations occur, reform through systemic change, and persistence through community advocacy. Marcus Whitmore, in a 2024 interview: "That day in the library wasn't about me being disrespected as district attorney. It was about me being presumed criminal because of my skin color. That happens to Black Americans every day: doctors, teachers, teenagers, people just living their lives. The difference is I had the position and platform to do something about it. I owe it to everyone who's experienced this without recourse to ensure it leads to change." Marcus Whitmore still researches cases at the county law library. Same mahogany table, same corner of the reading room, same yellow legal pads and stacks of case reporters. But now when deputies walk through on security rounds, they nod respectfully. They wave. They know who he is. More importantly, They know what happened. They know that assumptions have consequences. They know that suspicious isn't a legal standard. They know that in Crawford County, Georgia, a body camera, a determined prosecutor, and a community demanding accountability changed how law enforcement operates. The camera doesn't lie, bias does. If this case showed you how racial profiling operates, even against prosecutors in law libraries, share it with someone who needs to understand. These stories document what many people experience but can't always prove. If you have experienced something similar, you're not alone. Know your rights, document everything, demand accountability. This channel exists to show that justice is possible when evidence meets advocacy, when body cameras meet civilian oversight, when communities refuse to accept unfounded as an answer. Thanks for watching Bodycam Truth Files.